Okay, so I think if the panelists are in agreement, we can go ahead and start. Good afternoon, everybody, and welcome to Pissarro in the Courts, Foreign Sovereign Immunity Update 2022. I am Michael Todori, president of the Washington Foreign Law Society. The Washington Foreign Law Society was founded in 1952 to promote knowledge and understanding of international and comparative legal issues in foreign law. Today's session will be moderated by the great Juliana Canet. Juliana is a board member of the Washington Foreign Law Society and also its immediate past president. You might recognize her from all sorts of videos on the website, which I do invite you to take a look at. She is also executive secretary of the IDB Group Administrative Tribunal. A couple of very quick housekeeping notes before I let Juliana introduce the panelists. You can use the Q&A feature at the bottom of your screen to send us questions. We would rather you do it through the Q&A box and not the chat box, if you can remember. The session is being recorded and it will be reposted on our websites, and prior recordings are also available on the website, including prior programs on the Foreign Sovereign Immunities Act. And finally, don't forget to follow us on Twitter and LinkedIn. Our Twitter handle is @WFLS1952. One very final note, do please consider becoming members of the Society. There's a discounted rate for students and government or nonprofit employees. I'll be posting the link in the chat box. That being said, Juliana, the floor is yours.
Thank you, Michael. Welcome all. Let me briefly introduce you the panelists. We have a lot of ground to cover. Mark Feldman is the organizer of this great panel, and he has helped draft the FCIA and UNESCO Cultural Property Convention, and he has represented families seeking restitution of paintings stolen by the Nazis. We also have Sally Pay. He's a senior associate at Arnold & Porter with considerable experience in transnational disputes and foreign sovereign immunity. And then we have Peter Gutteri, has served in the Department of State Office of the Legal Advisor for a number of years and is currently working on sovereign immunity cases. You can find their full bios in the registration page on our website. So let's start with Mark, and let's begin with the very fresh and new Supreme Court decision on April 21st in Caceres v. Thyssen, Bordeminza Foundation. You filed an amicus brief supporting the Caceres family in this case. Please tell a little bit about what is at issue.
Thank you, Juliana, and thank you for moderating the panel, and I think for the growing audience, and people are signing in as we speak. I just want to mention that Juliana was the pandemic president of the Washington Foreign Law Society. And without her energy, extraordinary energy, we would never have had the wonderful, intense programming that we had during the pandemic. I also want to welcome Sally Pay and Peter Gutteri here. Let me say that I am delighted to have some new blood on these panels. I've been living with the Foreign Sovereign Immunities Act for more years than I care to remember. And we're fortunate to have from the younger generation two attorneys who are very busy working on these same issues. And each of them, I'm sure, is going to make a contribution to the law. And we are always reminded that you can do that in private practice and you can do it in the government as well. I also want to acknowledge David Pissarro, the lead plaintiff in the case that I'm going to speak about. We're honored to have him register for this program. And at some point I expect, I don't know if he's on listening to us as we speak, but I'm confident that he'll be looking in, and we're very, very delighted to have him with us. Let me say that the case of the Pissarro painting is a compelling story. And as we can see from the large registration, over 200 people have registered for this panel, whether it's because of the beauty of and importance of the painting, whether it's because of the horror of the Holocaust, or whether it's because of the perseverance of the Pissarro family, or even because of it highlights the complexity, frustrating complexity, I would say, of the Foreign Sovereign Immunities Act. But beyond all these considerations, which attract the attention of the media, of course, I would say that this litigation is a very important test case of basic principles relating to the law governing trade, illicit trade and stolen property, cultural property, and in the development of the Foreign Sovereign Immunities Act as well. The United States has been a leader in developing many of these principles on the international scene, but it remains to be seen whether whether those principles will provide justice in the courts of the United States. There's some fundamental questions that are at stake in this case, not just justice for victims of the Holocaust, but whether whether the norms developed with U.S. leadership over many years now, calling for the restitution of this kind of stolen property will be vindicated in our courts. And other questions such as the propriety, will the U.S. courts find the courage to transfer property, disputed stolen property, contested property held abroad by private parties and by agencies sometimes of foreign states. Let's begin with the facts and the legal issues in the Pissarro case. I'm going to watch the clock, Juliana, like you told me I should do. We're starting now. The essential facts are that the Nazis took the painting from the Pissarro family from their Berlin apartment in 1939. A certain prominent aristocrat, Baron Thyssen, I'll call him, purchased that painting from a New York gallery in 1976. He then sold it, or I should say, the Spanish government created a foundation to house the Baron's collection, and they bought that collection from the Baron for the foundation bought the collection, but the Spanish government funded it. That was in 1993. And as far as, if I understand the record correctly, it is conceded that the property is, or has been established in the courts below, that the property is stolen property, that the Baron was not a bona fide purchaser when he acquired it, and that the foundation never looked into the provenance, to the bona fides of the title to this painting when it acquired it in 1993. The other factor that's striking in this situation, this is the third case that the Supreme Court has heard in 2 years, the third FSIA case arising out of the Holocaust. But I think it's important to emphasize that this is not like the Pissarro case is not like the other cases that have arisen under the expropriation exception. There's no taking by Spain that's at issue here. The taking was by Germany. It's not a party to this proceeding. No sovereign act of Spain is at issue. It's a classic dispute over title to stolen property. In principle, I would say, the foundation stands before the court in the same possession as any private purchaser. The fact that the Baron sold his collection to an entity owned by a foreign state does not change the situation or the equation. Now, we've had 17 years of litigation in this case, which began in 2005, if I've got that right. 4 trips to the Court of Appeals for the Ninth Circuit, a full trial on the merits. and a detour to the Supreme Court. And at this point, the one remaining issue, the decisive issue to be decided below on remand, it's the whole question of the result, the whole outcome of this saga turns on the question of whether the applicable law is under the California choice of law rules is going to be the property law of California or the property law of the Kingdom of Spain. If California property law applies, the Pissarro family wins and recovers title to the painting. Because California, of course, has, like most common law jurisdiction, the fundamental principle that a thief cannot pass good title to stolen property. If the foundation, if, however, the foundation wins, if Spanish law applies, notwithstanding the facts that I mentioned, because Spanish law would provide for acquisitive, at least as determined by the courts below, would provide for acquisitive prescription based on 6 years of possession, regardless of other considerations. The only issue that was litigated below was whether that might have mitigated that was the question of whether the foundation was an accessory to the theft, and the courts below decided otherwise. So what happened below was that the Ninth Circuit rejected the Pissarro claim, and in so doing, it raised an issue that interested the Supreme Court. The Ninth Circuit held that the question of what choice of law that the choice of law to be applied is a question of federal common law in FSIA cases. There are four other circuits have decided the opposite, that in cases arising under the FSIA, where the claim is based on state law, that the law of the forum state should be applied. So the Supreme Court granted cert to resolve this conflict and had no problem in concluding by unanimous vote of the opinion that the FSIA makes clear on its face that in cases of this kind, that is to say where the cause of action is based on state law, federal common law does not apply. In fact, the statute says expressly that the foreign state shall be liable in the same manner and to the same extent as a private individual under like circumstances. And when I was working on the statute and to make the point absolutely clear, I added a sentence to the legislative history, quote, "The bill is not intended to affect the substantive law of liability." But it is my thesis, and the reason I wanted to address this case tonight is I think there's more that the Supreme Court's decision carries more weight than its resolution of this important but technical question. I believe that the Supreme Court has sent a powerful message to the lower courts on remand, and I quote the decision of the Supreme Court: "If a foreign state, if found ineligible for immunity, must answer for its conduct just as any other actor would." In other words, the court has, if the court has jurisdiction, the FSIA requires parity between private plaintiffs and foreign state defendants. We'll come back to that perhaps if other panelists are going to talk about the issue of comity, which is still to be resolved by the Supreme Court. Technically, the Supreme Court has only addressed the narrow issue which conflict rules apply. But I think that the message of the court is unmistakable. And I want to point out a little bit about how the case was argued, so that we can be confident that. And Juliana, I'm watching the clock, and I'll wind this up in just a minute.
Yes.
But the foundation, the reason why I'm so confident of this is that the foundation argued in its briefings to the Supreme Court the reason why federal, as a justification for the application of federal common law, that the removal provisions of the statute showed a congressional intent for uniform decisions by federal courts in cases involving foreign states. That is to say, they thought, and I think to this extent, the foundation was correct. The drafters were concerned that federal judges, that foreign states would be more comfortable in having an option of having federal judges as a general rule to be more even-handed than state court judges might be. But there was no merit to the notion that the foundation, in my opinion, that the foundation was propagating that the Congress intended uniformity of results across federal courts, across litigation against foreign states in state law cases. Justice Kagan, and I'm going to conclude with this opening intervention with this comment. Justice Kagan noticed this immediately during the course of the oral argument. For any of you who have listened to it, she saw the issue right away, and she asked counsel. She suggested that counsel was really asking for favored treatment for foreign states who are not immune to U.S. jurisdiction. And she asked counsel, where does that come from? It is not in the statute. It's contrary to the statute. And that is the message that the Supreme Court said. Sorry for running over the time a little bit.
No, it's fine. And it was very clear, Mark. Thank you for this introduction to the core issue. Maybe you can also tell us a little bit what is the issue on remand and what is the actually broader issue of this case at stake.
Well, of course, on remand, the Ninth Circuit is going to have to decide whether California, the Supreme Court has decided that California's choice of law rules apply. So the courts below will have to determine whether under that California rule, the California courts would apply in this circumstance, on these facts, the property law of California or the property law of Spain. And one of the reasons I think that this opinion helps the Pissarro family is that, as I read the record, the courts below gave undue weight to the fact that the foundation is an instrumentality of a foreign state, and to the fact that public funds of the Kingdom of Spain were used to purchase this painting. If those facts considerations are put on the scales, I think it gives a foreign state defendant, in any case arising under the expropriation exception, an unfair advantage, which has been rejected by the court, and I think in this case. Others may disagree. I'll be interested to hear what the other panelists think about that.
Thank you, Mark. Sally, any reaction to those this introduction and possible consequences?
Yeah, thanks very much, Juliana. And it's a pleasure to be here and have the opportunity to speak to all of you today. I do have reactions to what the point that Mark just made, but before I get to that, I just wanted to offer a standard disclaimer, which is that I'm here today in my personal capacity. And so the views I express here today are mine and not those of Arnold and Porter or any of the clients that we represent. So the point that Mark just made about the district court and the Ninth Circuit's choice of law analysis under California law, and the fact that the district court gave undue weight to the foundation's identity as a government instrumentality. I'm not sure I completely agree with that, and just want to come to the defense of the district court a little bit. And here's why. So the purpose of the conflict of laws analysis in any jurisdiction is to identify potentially competing governmental policies and to try to minimize the friction between them to the extent possible. And so the goal is to figure out which jurisdiction with relation to the case has the greatest interest in having its laws apply to a given issue in a given case. And in that respect, the identity of the parties in the litigation is always a relevant consideration. And so just to give you a sense of how this plays out in California, the approach that the California courts take is a three-step test. The first question is whether there is a substantive difference between the laws of the relevant jurisdictions. And for the reasons that Mark explained, it's clear that there is a conflict. And so then the court then moves to the second step, which is to figure out whether this is actually a true conflict. And that means that the court looks at the purpose underlying the law, the policies that the laws were designed to affect, and considers whether either of the parties is actually in the class that the state law was designed to protect, and is designed to be a beneficiary of the policy that the law is supposed to further. And so, this is really to figure out whether the state, not with respect to its presence in the litigation, but just as a state that has enacted laws that may be applied in the case, has any skin in the game. And then third, the court will look at which state's policy interests would be more impaired if its law were not applied. And again, this is not looking at the specific presence of the state in the litigation, but just the state's general policy interests that are at issue. And so here, the district court statement about the foundation status as a government instrumentality really comes in the context of step 2. It identifies the fact that Spain has a policy interest in applying its law on adverse possession, and points out that those policy interests are implicated here. Interest in promoting the certainty of title and protecting defendants from stale claims. And so they're at play in a case where one of the parties is an entity that's located in Spain. And so that fact should be weighed in the analysis. The foundation, again, is a member of the category of persons that the law is designed to protect. And so I don't think that recognizing that fact amounts to putting a thumb on the scale in the favor of defendants or giving them a substantive advantage. It just places it on, in the range of considerations that the court is going to weigh. Bear in mind that there are also going to be California law considerations and policy interests that are lined up on the other side. And so this very same mode of analysis would also apply to claims against a private foundation. And I think probably the same result would pertain if the private foundation were also located within Spanish territory. So that was my reaction to Mark's point on choice of law. And I'm going to move on now and spend the rest of my time discussing another significant new Foreign Sovereign Immunities Act case in the cultural property space. And that's the DC Circuit's March 2022 decision in De Teppel versus Hungary. And just a very brief background on the case for those of you not familiar with it. The case involves the Herzog collection, which was a vast art collection amassed by a Jewish art collector. And it was taken by Hungarian authorities during World War II. After the war, the Herzog family embarked on a decades-long quest to recover the artwork, both before Hungarian courts and also here in the United States. And so in the United States, the case has been actually kicking around in the federal courts for a long time as well, since 2010. And this particular opinion marked the third trip to the DC Circuit for these parties. The DC Circuit in this particular opinion addressed several issues, but I'm just going to focus on one of them in the interest of time. And that's whether the FSIA's expropriation exception provided jurisdiction over claims against the Hungarian National Asset Management, Inc., MNV for short. And MNV is a state-owned entity that exercises ownership over and manages state-owned assets. Now, the key question here was whether MNV is an agency or instrumentality, or whether it's instead part of the state itself. And doctrinally, that's a really important threshold determination for a couple of different reasons. And first, most relevant here, it's important because the expropriation exception sets forth less stringent standards for claims brought against agencies or instrumentalities as compared to claims brought against the state itself. And I'll just note that the distinction matters in a couple of other contexts as well. There are different rules for service of process, different rules about attachment of assets, and about punitive damages. So it's really a determination that has consequences. And for a determination that has such weight, you might expect the test for how to figure out whether something is an agency or instrumentality or part of the state itself or the state itself to be a clear and straightforward matter. But the analysis in DITSEPL shows otherwise. So in DITSEPL, what the DC Circuit did was to apply what's known as the core functions test. And essentially, the court looks at the entity's principal functions and asks whether they are governmental or commercial. And if they're governmental, the entity is considered part of the state itself. If they're commercial, the entity is an agency or instrumentality. And here, MNV's core functions were the management of state-owned assets. And the DC Circuit recognized that managing property generally can be a governmental or a commercial act. So ultimately, the court said that what had to be determinative was what kind of assets the entity was actually managing. And here, those assets were state-owned movable property, real estate, and state-owned enterprises. And so the court said, well, this is commercial activity because private entities can also manage assets of that type. And so on that basis, the court concluded that MNV is an agency or instrumentality and not considered part of the state itself. And so all the consequences that flow from that decision are the ones that I mentioned. And so I want to offer just two comments on this core functions test. First, as a matter of textual interpretation, it's not, to me, based on a convincing interpretation of the statute. The key question under the statute is whether the entity is a, quote, separate legal person, corporate, other, or otherwise, end quote. And nothing in that definition indicates that you're supposed to look to the functions or activities of the entity to determine whether it is an agency or instrumentality or the state. And notably, if you look at the opinion in DITSEPL itself, it doesn't actually locate any portion of the statute to support this core functions test. Instead, it cites a 1994 DC Circuit case called Pissarro versus La Fuerza Aérea Boliviana, which was a case that concerned service of process on the Bolivian Air Force. And this is the genesis of the core functions test. In that case, a divided panel of the DC Circuit adopted this test over a strong dissent from Judge Mikva, who pointed out the lack of statutory basis for the core function approach. Judge Mikva also pointed out that the legislative history points to a different interpretation of this concept of separate legal person. And basically, this notion of separate legal personhood was intended to refer to an entity that can sue or be sued in its own name, contract in its own name, or hold property in its own name. And the majority in Pissarro actually recognized this, but said that, well, the House report that contains this very explanation of Congress's intent was internally inconsistent, and therefore the court decided to adopt its own analysis that it believed resolved these purported inconsistencies. I think using the commercial versus government activities distinction as the touchstone for agency or instrumentality status also makes very little sense in light of the rest of the statutory structure. The FSIA creates exceptions to immunity for sovereign defendants, which are both foreign states and their instrumentalities that engage in commercial activity. So it's a little odd for this distinction between agency and instrumentality and foreign states to turn on this same kind of commercial versus governmental dichotomy as well. And of course, I think the fact that there are express references to commercial activity elsewhere in the statute just highlights that if Congress wanted to make commercial activity the touchstone of this kind of analysis, it could certainly have said so. And perhaps Mark will have views about that. And despite the lack of statutory basis for this test, it's interesting that the courts of appeals have all apparently coalesced around this core functions approach from Pissarro. To my knowledge, all of the appellate courts that have considered this issue have adopted the Pissarro test. So for the time being, at least, it seems like it's largely here to stay, and it's the mode of analysis that foreign sovereign defendants in particular are going to need to grapple with. That leads me to my second comment, and I'll try to wrap up quickly. And that comment is more on the practicalities of this decision. So one of the considerations that apparently motivated the Trans-Aero Court to adopt this core functions test was administrability. The court said that the test would tie the analysis to sort of obvious functions rather than uncertain, legal authorities of foreign defendants. And in the court's view, it seemed like this kind of analysis was more straightforward and easily applied than delving into foreign law about the status of different entities. But I think DCEPL really brings that proposition into question. The previous cases that applied the core functions test largely involved fairly straightforward facts, what one might consider easy cases. I mean, Trans-Aero itself was about service of process on the Bolivian Air Force, and other cases involved claims against armed forces, ministries, embassies, where there's little doubt under any test that those kinds of entities are performing government functions. But state-owned entities in cases like this one are much closer to the line, and I think that's why the DC Circuit ended up engaging in these kind of fact-intensive inquiries about what type of property is this entity actually managing. And to me, that it's quite questionable how easily administrable this kind of inquiry actually is. And I'll just point out that the governmental versus commercial activity dichotomy is one that courts and litigants grapple with all the time in the context of cases that are brought under the commercial activity exception to the FSIA. And those cases, as we know, are very fact-specific, very fact-intensive. They can involve a substantial amount of fact-finding. Often jurisdictional discovery is needed. And so this is obviously a very burdensome exercise that itself arguably entrenches on the presumptive immunity of foreign sovereigns. And so again, it's I think this particular decision just sort of exposes some of the new and uncertain territory that the DCEPL application of Trans-Aero has exposed. And I think I'll leave it there for the time being and look forward to reactions from my fellow panelists.
Thank you, Sally. Peter, is after this constellation of cases, the test clear? Does it make sense? Can you tell us a little?
Of course it's clear, and I have all the answers to give you. So I will start with a similar disclaimer to Sally's, that I'm here in a personal capacity today and not here as reflecting necessarily the views of the United States or the State Department. So, and I will start just by expressing my thanks to the Washington Foreign Law Society, and particularly Mark for organizing us, and Sally for joining, and the opening remarks from both of you, which are going to be hard to top. So, but let me try to just comment on both of what you've said very briefly, and then maybe just add one more issue into the mix if we didn't have enough to discuss in the remaining time. So maybe just to start with Sally's, since what she said is fresh on my mind, and I don't want to lose the thought. So in terms of this issue of the courts determining whether an entity is an agency or instrumentality, or is a political subdivision, and thus, the foreign state itself under the FSIA, I mean, I think Sally has really hit on an interesting issue that I think, in light of some of the earlier DCEPL decisions of the Court of Appeals, becomes a lot more relevant. And Sally pointed out that there are certain provisions of the FSIA that distinguish, between those two categories, like service of process and execution immunity. But in general, I think the courts have, for jurisdictional immunity purposes, treated them largely the same. But then you have an earlier version of DCEPL looking at the expropriation exception and kind of clearly delineating between the foreign state on the one hand and agencies and instrumentalities on the other for purposes of jurisdiction. And so, what the distinction that Sally is pointing out and the court was grappling with in the most recent DCEPL case, I think becomes all the more important. And Juliana, I'm afraid I don't have the answers to that, but I do think that it is an issue that's worth monitoring. And then maybe just to flag, as courts in different circuits grapple with this, I think there's also been a more recent Fourth Circuit decision with the Netherlands. I think it's Berg v. the Netherlands, if I'm not mistaken.
Yeah, that's right.
Yeah, where the court is really the Fourth Circuit's trying to grapple, I think, with what the DC Circuit said in DeShepel. And in that case, the Fourth Circuit actually came out and found that the Dutch ministry that was at issue in that case, was a political subdivision. So it was not an agency or instrumentality, or upheld the district court's finding, I think is how it worked procedurally. So, and it's interesting to see how the circuits are kind of, grappling and kind of talking to each other a little bit. And it seemed to me like the Fourth Circuit was very much trying to distinguish the facts of the DeShepel case from the ones that it was presented with respect to this Dutch ministry, and also, did pay attention not only to the functions. I think that it also, did some of the functional analysis that you were talking about, but also the form and structure and kind of legal status of the entity there. So I don't know whether that portends, a developing circuit split, or if this is all just kind of, application of different facts to the same test. But I think that issue that Sally has raised certainly bears monitoring. Is we see more of these cases, and these cases are certainly continuing. So, and then to return to Pissarro, I think the first thing that I would say is I encourage everyone, if you haven't already done so, read the Supreme Court decision, because Justice Kagan wrote what is really a beautiful decision. It's very approachable. It's easy to read. I think for lawyer and non-lawyer audiences alike, and it's short too. It's relatively that I think that's part of what makes it approachable. And I have to highlight, like, one of my first reactions in reading the decision is, and I think this is fairly unusual, although I'm not necessarily an expert on Supreme Court practice, but there's an appendix which actually has the painting in the appendix, and then a second one which I thought was I think there's probably some meaning here, a second photo of the painting in the property, from an older photo that puts it in the context of this case. So not only is the writing interesting there, but I think how just the fact of the appendix is pretty interesting there as well. But on Mark's question, because I think he's identified correctly the issue now on remand as an issue of choice of law, and kind of how California choice of law principles now get applied. And I'll say at the outset, this is not something that the US government has taken a position on, and I certainly don't fancy myself as an expert on California choice of law principles. I think I learned a lot just from listening to Sally's presentation on this point. I had a little bit of the same reaction as Sally did, that in terms of the choice of law analysis, and which we now know is under California law, one of the things is to point out is that when the district court did the choice of law analysis, it did it both as a matter of federal common law, and it also did the analysis as a California choice of law under California choice of law principles, because there was some uncertainty as to where the Ninth Circuit stood. The district court did both analysis. And I had a little bit of the same reaction, that it seemed like that analysis was pretty focused on Spain's interest in regulating conduct within its borders. And it seems to me like that analysis, one is a legitimate choice of law consideration to take into account, and two, is probably the same regardless of whether you are talking about, regardless of who the defendant is, and whether it's a state entity or a private party. And so again, that's not necessarily to say whether the application of the choice of law rule was the correct one in this case. But I do think that it shows that even the application of the choice of law rule, now that the court has confirmed what that rule should be, is not necessarily an easy one. And that's particularly true in these types of expropriation cases, where the relevant conduct, necessarily is going to have a foreign nexus to it. So one other thing, just to flag on Mark's comments, and that I would welcome his further thoughts on. I think at the beginning of the presentation, he highlighted that the norms developed under US leadership and how they will be vindicated in US courts. And I think that picks up on a theme in his amicus brief as well, where, and Mark, if I'm misconstruing, by all means, correct me, but where he suggests that the Washington principles, in undertaking the choice of law analysis, that the court should be giving serious consideration to the Washington principles. And when I read that in the brief and listening to Mark, that really prompted two questions in my mind. First, so, as a general matter, to what extent should courts be taking into account those types of foreign policy considerations when conducting a choice of law analysis? Certainly possible to envision a future case, not necessarily this one, where the United States might have some important foreign policy consideration that it wanted to bring to the court's attention in terms of what law should be applied to cases with strong foreign nexus. So I certainly wouldn't discount that possibility, but I think there's a question as to what the court's appropriate role there is in the limits of that. And relatedly, to what end are courts, so to the extent that it's appropriate, to what end are courts taking these considerations into account? So just to take this case, for example, do the Washington principles necessarily point us to the choice of law or to what law should apply in this case? And so Mark would welcome your thoughts on that. And then finally, just to wrap up, and as promised, to introduce one further issue into the mix here, and Mark alluded to it in his opening remarks, and that's the question of comedy. And while that question has not been as central to the Cassier case, it is a question that the court left a little bit unresolved in the prior term in the Simon v. Hungary case. And just to frame the issue for further discussion here, the question there is that once a court establishes that it has jurisdiction under the FSIA, so there is no immunity bar to bringing suit against the foreign state, does that court maintain the discretion or the ability to decline to exercise jurisdiction on comedy grounds? And so take, for example, a situation where the court is satisfied that the foreign state has provided a sufficient remedy or recourse to the plaintiffs. Can the court then say, on a comedy basis, the case will not move forward in US courts? So I think that's the question. I know the other panelists have thoughts on that, so I will open it up to them with just one maybe initial note on that. And that's to bring us back to one of the principles animating the Cassier decision that I think has some bearing here. And that is, once FSIA jurisdiction is established, as we've heard, the FSIA directs that the foreign state be treated similar to a private litigant under like circumstances to the extent that's possible. And so to the extent that comedy itself is a prudential doctrine that's available to private defendants, why shouldn't it be available to foreign states in the same manner as it would be? Isn't that just an extension of the very principle that we've been talking about here? So with that, let me turn it back over to Juliana to guide us.
Thank you, Peter. So before, I want to show you the paint in the original room to remember what we're talking about. And Mark, the floor is yours, and maybe you can also address the question we receive about immunity v. liability. Thank you, Mark.
Good. I've just addressed that one on the chat. The questioner was quite correct. The whole point is that the arguments about immunity, that there's a statutory interest in uniformity of decisions on immunity, but absolutely not on questions of liability. Anyway, this is really exciting. We've had two very, very good interventions, and they both challenged me, and I like that. I wish some of the students at Georgetown would do as well. Let me start, Peter, with your last comment, and I feel very strongly about it. And that is that in drafting the Foreign Sovereign Immunities Act, both the executive branch, including the State Department, and the Congress made determinations involving the reciprocity and comity interests of the United States. the statute is one of the reasons that it is so complex is that the Justice Department craftsmen, and it was, I have to credit my predecessors, because this structure of the fundamental structure of the bill was created by my predecessors in the first bill that President Nixon sent to the Congress. By linking immunity determinations and subject matter jurisdiction to the existence of territorial connections. From the point of view, I think, of the continental law system and even the International Court of Justice, we've scrambled categories here, but I applaud them for addressing the question, not just what is, when should a state be immune or not, but the underlying question of when should a U.S. court or a national court pass judgment on the actions of or interests of a foreign state. And to my mind, it is absolutely clear that those things were weighed very carefully, both in the executive branch and in the Congress. And it was intended, and particularly in the expropriation exception, that where the criteria were met for a U.S. connection, that the court should proceed and certainly not let the foreign state be the judge of its own case, where by definition, I mean, the whole purpose of the expropriation exception was to reach foreign takings of property by foreign states in their own territory. And that is also part of my response to Sally's very, very cogent. There's no doubt that this is not an easy case for the Pissarro family on remand, because I think there's a kind of momentum behind that traditional knowledge or approach, or choice of law approach that Sally articulated. But I read that district court decision differently. I think they were very much influenced. And by the way, the Court of Appeals has not made that analysis of California law. And I think that the posture before the Court of Appeals is infected by undue weight given to the state's interest as a participant in the transaction. And that is at the heart of State Department concern about the expropriation exception. Without going into the great detail, you can look at my views in my brief that I filed in the Simon case. The current generation, well, let us say that Joseph was once popular in Egypt, but the current pharaohs in the State Department don't recognize the judgments that were made by their predecessors in Monroe Lee, the generation of Monroe Lee in the Ford Nixon administration. They really don't like the expropriation exception because it makes foreign countries annoyed. And the whole purpose of this exception was to give primacy to the interests of US investors who were subject to these kinds of expropriation. And at that time, it was a major foreign policy issue. Turning, Sally, to the other case, the DeCepel case, I couldn't agree with you more. In fact, I can remember that one of the, as I saw it at the time that I was reviewing all of this material and trying to establish a consensus draft that Congress would act on in 1975 and 76. I remember that one of my opinion, whether it's in total, I don't have a historical proof of this, but my opinion based on the cases that had been bothering the department in that time frame was that the drafters extended the protection of the statutory regime, the FSIA, to agencies and instrumentalities precisely because they thought that this issue of the functions of the entities was unmanageable. And you also had questions of foreign government, and I think it was Russian, actually. It was a case involving a Russian entity where the issue arises, and I'm sure it's still a problem in the State Department. What does a court do when a foreign a government or one of its witnesses misrepresents the facts? In fact, we did have a case like that involving China not too long ago, where the courts had to deal with that issue. So I have a very clear belief that the drafters and in the executive branch and the Congress made a definite decision contrary. The last thing we wanted the courts to be considering was to define. The U.S. government had rejected the notion of defining agencies and instrumentalities by virtue of their function. That is my best recollection of this.
Thank you, Mark. Actually, we do have a question that might liaise well now about possible confiscation of assets without congressional action, and how will FSIA, if any, will play the role here in the more current situation. Who would like to take the question? Maybe Peter? Or Sally?
Sorry, I'm trying to find the question. I don't, maybe the other panelists have it in front of them, and while I try and open it.
Yes, I can read aloud if you want. Behind the cultural arena to the Russian invasion of Ukraine and the current question of whether under FSIA treaties or customary international law, sovereign assets are subject to confiscation in cases of crimes against humanity to be distributed to victims of such crime in support of or opposition them. So if you can comment how might be linked the situation, the current situation.
Right. So I think as a general matter, if it's an issue of restitution to victims and victims bringing kind of specific claims in U.S. courts, then I think the FSIA definitely speaks to that. And the threshold question is whether one of the exceptions to sovereign immunity, assuming that Russia, the state, or one of its would be the defendant, whether one of the exceptions to sovereign immunity would apply there. And so obviously it's impossible to speak to that in kind of the hypothetical case, but that would be analytically, I think, how it would be looked at. Now, I think one of the things that certainly is in the public sphere is whether Congress might enact legislation, and I don't know what that legislation would look like, or whether that would touch on sovereign immunity issues or kind of other issues that might be in play here. So, but I think to the extent that you're talking about U.S. court claims against the Russian state, then you are very much looking at the FSIA framework in terms of analyzing those.
Thank you. Sally, any additional points?
No, I agree with Peter's take on this question that we've received from the audience. I think the FSIA would supply the relevant framework. I just wanted to pick up on Peter's point earlier about international comedy and Mark's reaction or mention of it as well. I agree that in light of the logic of Cassirer, it seems like to the extent that international comedy remains a defense that's available to private parties, it should be available to foreign sovereigns as well in litigation brought under the FSIA. But I think there's, that sort of leads to questions that are sort of beyond necessarily just the relationship between the FSIA and doctrines like international comedy. International comedy itself is a very old doctrine. I think the main Supreme Court case that we all cite when we talk about comedy is from the 1800s. But interestingly enough, the Supreme Court itself hasn't weighed in really on the contours of the doctrine for quite some time. The leading cases are currently from the 11th Circuit and the 9th Circuit, and there are sort of complicated multi-factor balancing tests that these courts apply. And so there are questions about the propriety of those tests, what the test should look like. And there are also some questions about the relationship between international comedy and other doctrines, such as forum non-conveniens and the active state doctrine that, at least broadly seem to accomplish similar purposes. And so what is the distinction and relationship between all of these? And those are some questions as well that that came out in the oral argument in Simon. I think several of the justices were quite, they were probing sort of the relationship between all of these different strands of arguments and doctrines that tend to come up in these kinds of cases. And so as the lower courts, I think, are tasked with addressing questions of international comedy and deference and respect to foreign sovereigns in cases with increasing frequency, I think the time is ripe for the Supreme Court to weigh in at some point. The question of whether they will do so in a FSIA case at the moment under the expropriation exception is still alive. As Peter noted, they punted on that question last term. So, but the circuit split is still out there. So in theory, I suppose they could take it up again. But we'll just have to stay tuned. But it is very much a live issue and one that many of us are keeping a close eye on.
And we have another question that
Yes.
we addressed on the chat.
You would so let me read aloud. I think we have time for this. And Mark, if you want to check on this one, will the act of state doctrine be available to defendant in this case, which would obviate the choice of law issue on remand?
Well, I think that really goes to the essence of the problem in this case. Can a foreign sovereign be the judge of its own actions under the expropriation exception? First of all, I would argue that there is no act of state as defined by the cases in this situation, and that's something that I was trying to express earlier. The foundation purchased this painting. That's not an act of state. That's not a sovereign act. That's a commercial act by any definition. And the fact that it happens to be owned by a foreign state doesn't change that. The other thing is that the argument has not been made, and I assume it's waived and can't be made at this late date. But I just want to flag another issue out there. We don't have time to discuss it. But the newest justice of the Supreme Court, pending, has written a wonderful opinion on the Foreign Sovereign Immunities Act, but raises an issue which is a serious intellectual challenge for judges and lawyers based on the complexity of the statute. And that is whether the defense of immunity can be waived. And the answer from the point of view of the drafters and the Congress and the doctrine is that, of course, a defense of immunity can be waived. And it can be waived, for example, by an appearance in the court without asserting it. But on the other hand, the statute ties foreign's immunity to subject matter jurisdiction. And in this particular case, I don't recall the name of it right now, but it involved Iraq, if I recall correctly. There was a question of whether a late argument could be made, and the justice opined that since subject matter is at issue, the court can always be raised. Fundamentally, it can't be waived. Now, I'm not saying that was wrong on the facts, because I don't even remember exactly, but I was struck by the complexity. And one of the reasons it reminded me of an argument Russia recently made in the Chabad case, which was rejected, maybe not head on, but the motion of Russia to dissolve the award against Chabad on other grounds was rejected for procedural reasons. And by the way, I want to point out, I put on the record that while DeCepel has decided for the DC Circuit that there is a different standard for agencies under the expropriation exception than for the state itself, it earlier decided differently in the Chabad case. And I think, as I've written many times, and most recently in a brief to the DC Circuit in Cavad, I think that's the correct interpretation. The framers didn't have that in mind. We want the foreign state to be, for example, if Russia expropriates an oil company and then wants to sell that oil in the United States, but it transfers the oil properties to an independent agency, and that agency is doing business with the oil in the United States. I would argue that the statute, that the foreign sovereign is subject to the jurisdiction of the U.S. state for its act of expropriation under the FSIA. That is not the law in the DC Circuit going forward.
Thank you, Mark. I think we are in a 1 hour mark, and I hope we stimulate your appetite for more panels on this issue. Michael, you want to?
Thank you, Juliana, and let me thank all the panelists for a terrific conversation. Thank you, Peter. Thank you, Sally, and of course, thank you, Mark, for as always a great panel that you set up. I would invite everybody to remain tuned with the Washington Foreign Law Society. We do have a number of events coming out soon, so please subscribe to our newsletter and check out our website, wfls.org. That being said, I wish everybody here a great night or evening. Take care, everybody. See you very soon.
Thank you, Mike. Thank you for a great
Bye.
panel.
Thanks, everybody.
Bye-bye.